viewers, welcome to our channel. From this channel, we will have some ideas on different types of laws and definitely get some ideas how does law can help to their daily life relating to injury cases, accident cases, etc. So viewers, without wasting any time, let's go to our new video. If you like this video, please subscribe our channel, give like to our channel and don't forget to press the bell button so that if you press this bell button you will get the notification when our new video will be released. So let's go to our new video and let's see what we can learn from this video. Thank you. So today we will learn about tort law. Tort in common law, civil law, and the vast majority of legal systems that derive from them. Any instance of harmful behavior such as physical attack on one's person or interference with one's possessions or with the use and the enjoyment of one's land. Economic interests under certain conditions, honor, reputation, and privacy. The term derives from Latin tortum, meaning something twisted or wrong or crooked. The concept encompasses only those civil wrongs independent of contracts. Other legal systems use different terminology for this wide and amorphous area of the law. Despite differences of terminology, however, this area of the law is primarily concerned with the liability for behavior that the legal order regards as socially unacceptable, typically warranting the award of damages to the injured party or occasionally an injunction. So here we can see an example. Germans, for example, talk of unlawful acts and French-inspired systems use interchangeably the terms deliits and quasi-deliits and extra contractual civil responsibility. Terminology. The person who commits the act is called tortfeasor. Although crimes may be torts, the cause of legal action in civil torts is not necessarily the result of criminal action. The harm in civil torts may be due to negligence, which does not amount to criminal negligence. The victim of the harm can recover their loss as damages in the lawsuit. To prevail, the plaintiff in the lawsuit, commonly referred to as the injured party, must show that the actions or lack of the lawsuit, commonly referred to as the injured party, must show that the actions or lack of actions was the legally recognizable cause of the harm. The equivalent of tort in civil law jurisdictions is delicate. Moreover, tort law differs from criminal law, which both contain punitive elements. Tort law is known to be more vindicatory and compensatory by nature. The overall project of tort law is to define cases in which the law may justly hold one party liable to compensate another. Legal injuries are not limited to physical injuries and may include emotional, economic, or reputational injuries as well as violations of privacy, property, or constitutional rights. Torts comprise such varied topics as automobile accidents, false imprisonment, defamation, product liability, copyright infringement, and environmental pollution. Toxic torts. Compared to criminal cases, tort lawsuits have a lower burden of proof, namely preponderance of evidence rather than beyond a reasonable doubt. Sometimes a claimant may prevail in a tort case even if the defendant who allegedly caused harm were acquitted in an earlier criminal trial. For example, O.J. Simpson was acquitted in criminal court of murder but later found liable for the tort of wrongful death. So these are legal injuries. It's broadly true to say that most Western European and common law systems tend to regard as actionable the same factual situations. But although the problems encountered are identical and the results reached are often quite similar, the arrangement of the law and the methodology employed often differ significantly between countries depending on how the law has been conceived and how solutions have been approached in various cultures over time. Thus, the German Civil Code reflects a strong tendency to abstraction and systemization, qualities that betray the code's university and Roman law origins and that contrast at least superficially with the more casuistic, cause-based, definitely, and judge-made law of the common law systems. By contrast, the 19th century codifications, which are the products of natural school of law, are marked by their broad sweep and manifesto like provisions, often making them more readable than their German counterparts, but also less precise and accordingly in need of judicial definition. Typically of this approach is the Napoleonic Code of 1804, which became a model for most Romanistic legal systems, including those of Italy and Spain and their derivatives, mainly the Central and South America. Much of the contemporary law in these countries results from the interplay between judicial activity and doctrinal writing. Now, tort law viewed as secondary to contract law. Tort law, though often viewed as secondary to contract law, in the law of civil obligations spread to many parts of the world after World War II, and its influence was especially notable in continental Europe. At the same time, criticism of it has led to its replacement either partially by specialized schemes or, in rare cases, by complex systems of accident compensation. Criticism has also provoked serious discussion about the impact of the welfare state, modern insurance practices, and the importance of economic analysis in the proper development of the law. For a time, it even looked as if these challenges might bring about wholesale reform, such as that adopted in New Zealand in the 1970s, that would threaten rules with very ancient pedigrees. Both the 20th century closed the tort system remaining basically intact, which held to a lower status with the entire system of compensation, as the majority of compensation of reparable injuries continue to be paid through social security systems and insurance claims. Now we will learn something about functions of tort. Throughout its long history, tort has pursued different aims: punishment, abasement, deterrence, compensation, and efficient loss spreading of the cost of accidents. None offers a complete justification. All are important, though at different stages one may have been more prominent than the rest. This has been observed by Professor Allard. There can be no justification other than interior for the continued application of the unreformed English law of torts in modern African countries. Sorry, there is no doubt that he was right. There is equally no doubt that it is still substantially the unreformed law which is applied. Certainly, there has been very little in the way of legislative change. This paper is not concerned mainly with these questions, but with what uses African litigations and their lawyers have found for this exotic field of law, and also to some extent with the further question of how far the law has proved fitted for the task. It has been said of the anti-Ogin law of tort that it does not in general reflect the Australian outback and its pastoral economy, nor New Zealand's earthquakes, volcanoes, and glaciers, and nor exemplify an Australian or New Zealand ethos. So, punishment and appeasement. Originally, tort and criminal law were indistinguishable, and even when the two branches began to acquire independent identities, the former remained for a very long time in the shadow of the latter. Offensive against the community and the king's interest increasingly became the subject of criminal law, whereas wrongs against the individual came to be dealt with by the emerging, or in the case of continental Europe, emerging Roman inspired law of torts. Early tort law, however, was concerned only with the most serious kinds of wrongs, bodily injury, damage to goods, and trespass to land. Not until the 19th century was it extended to cover such conduct as intentional infliction of economic loss. In the 20th century, the compensation of negligently inflicted economic loss and other violations of subtler interests, such as psychological injuries and violations of privacy, took center stage in the wider debate that aimed to see the proper boundaries of tort liability. The emancipation of tort law from criminal law resulted from the need to buy off private vengeance and to strengthen law and order during the Middle Ages. Most authors would probably agree that punishment and appeasement are no longer major aims of tort law. Nevertheless, some common law jurisdictions, notably the United States, retain in their damage awards a strong element of punishment of certain types of tortious conduct. These punitive or exemplary damages, as they are sometimes called, are in England limited to three rather narrow instances. The most troublesome and often encountered is the case of an activity calculated by the defendant to make profit, a term not confined to money making in the strict sense. In these instances, it is felt that it is necessary to teach the wrongdoer that tort does not pay by making him not only compensate the plaintiff for the latter's loss, but also discharge any gain he may have made from his conduct. This is right. Few would doubt. Less definitely, however, is the resulting windfall for the plaintiff and the loss of important procedural safeguards for the dependent in a situation in which punishment is meted out unpredictable and unguided juries. In England, the later objection was partially countered by the supports greater willingness encouraged by modern statutory rules to control such jury hours and to keep them with reasonable limits. But the same cannot be said of the United States, where punitive hours often amounting to millions of dollars and significant effect on the tort strategies of litigants. Notwithstanding these doctrinal doubts, the award of punitive damages remains possibility in some common law countries, especially the United States. Favorable attitudes towards punitive hours may arise from a multitude of factors such as sudden dislike of regulation as means of influencing human conduct, that is, to prevent accidents, the existence of contingent fees, and the desire more keenly felt by juries to punish wealthy defendants. In the United States, these and other factors deeply yet indirectly affect tort law in practice and account for some of the major differences from its progenitor, the English law of torts, with which the American progeny otherwise has much conceptual affinity. Civil law systems have, by contrast, take hostile attitude toward penal damages in civil actions, though there are limited instances in the German law of tort privacy and the French law of contract astreint, in which a penal element has been allowed to creep into the civil hour. Deterrence. In its modern economic sense, deterrence aims at reducing the number of accidents by imposing a heavy financial cost of unsafe conduct. A distinction is necessary between specific and general deterrence. The former depends largely on the admonitory effect of tort law. This, however, is limited where insurance cushions the defendant from the economic consequence of an adverse judgment, though insurance premiums may subsequently be increased. This deterrent element, however, almost completely evaporates in the case of traffic accidents, where harm is statistically inevitable and in most cases results from the momentary inattention, the occurrence of which no tort award can ever prevent. Tort law is therefore in some cases the second best means of preventing accidents after criminal law. Its greater influence, it means deterrent influence, may be in cases involving damage to property and totals harm resulting from intentional activities. Very different was theory general deterrence principally argued by the US legal scholar and judge Juju Calabresi in the Cost of Accidents 1970. In Calabresi's words, general deterrence involves deciding what the accident costs of activities are and letting the market determine the degree to which and the ways in which activities are desired given such costs. Similarly, it involves giving people freedom to choose whether they would rather engage in the activity and pay the costs of doing so, including accident costs, or given the accident costs engage in safer activities that might otherwise have seemed less desirable. But is it possible to rely on the degree of rationality in human behavior seemingly presupposed by economic theories? And is it always possible to identify the activity that causes the accident? For example, a tool defectively manufactured by injuries one of B's employees who has been supplied with it by B, whose activity has caused this injury. And in accidents involving automobiles and pedestrians, can such an economic choice be made? Calabresi treated the motorist as the best cost avoider on the grounds that he has both better information and the means of reducing such accidents. But are such assumptions truly enable? Finally, general deterrence, so conceived, cannot provide all the answers, as Calabresi was well aware. Wider considerations of fairness and justice also obtained, and it would be a mistake to assert that certain antisocial activities can and will be allowed so long as those taking part in them are prepared to pay for them. Moreover, collective judgments are often reached and an infinite number of calculated risks determined according to political criteria rather than cost benefit equations. Thus, although economic analysis has spawned some imaginative writing in the area of tort law, it seems to have left the courts rather indifferent. This is especially true outside the United States. Yeah, compensation. Compensation is arguably the most important temporal function of tort law, and modern insurance practice has made it considered easier to satisfy the injured without financially crushing the injurer. The welfare state, however, is now the main source of accident compensation, but even where tort law plays a major compensatory role. For example, in the most serious cases of personal injury, it does not function with great efficiency. Though tort lawyers rightly regard tort as a compensation system that caters best to the particular victim on the basis of the pre-accident situation and prognosis of his future, it nonetheless remains expensive, capricious, and dilated. The Royal Commission on Civil Liability and Compensation of Personal Injury in 1978 in England once estimated that it cost 85 pence to our £1 of net benefits to the victim. The administrative cost of the New Zealand scheme was apparently less than 10%. Tort law as forensic lottery. The tort system is capricious in that compensation may depend on finding a tortfeasor, wrongdoer, and a credible witness, not to mention a good lawyer. Delay can also produce injustice, especially since it tends to benefit wealthy defendants unusually. Usually, insurance companies whose in-house legal advisors can sometimes delay payments in the hope of wearing down a plaintiff so that he accepts a low settlement. Difficulties of this kind have led some authors to refer to the tort law as a forensic lottery and have given rise to remedial legislation in areas particularly affected, such as automobile accidents. Most importantly, they have led many juries to reconsider the utility of modern tort law. Nonetheless, threatened a radical overhaul of tort law has not taken place. Now, law spreading. Compensation in its crudest form meant that the cost of an accident was shifted from the victim to the tortfeasor. For a long time, the only plausible cause excuse for such a shift was deemed to be the tortfeasor's fault. Certainly, it seemed right to make wrongdoers pay. This has revolutionized tort reasoning, for victims can now be compensated without tort fees being ruined financially. It thus helps erode the requirement of fault while strict liability correspondingly proliferates as see below liability without fault. Finally, where liability without fault has not been introduced is an open manner. Such notions as fault, foreseeability, and causation become stressed in an attempt to do justice to the victim while allegedly remaining faithful to a fault-based law of torts. It is only since about the 1960s the Anglo-American courts have tended to refer openly to such considerations, and they have been active not only in shifting the loss but also in trying to pin it on the person who is in the best position to spread it. Comparative classification. Although common law of torts is in many ways wider than the modern European law of deeds, in practice it hides a tendency to deal with tort problems under different headings of the law, such as contract property, inheritance, or even crimes. For example, in English common law, tort has served such modern problems as product liability or liability for negligent statements, whereas French and German law has traditionally relied on contractual solutions. In contrast, the German Civil Code has a basic provision excluding compensation for negligently inflicted pure economic loss that, along with the narrow rule of fisheries liability, has encouraged the expansion of the law of contract. Defamation also is regarded primarily as a tort in the common law but as a crime in civil law systems, though in some of the latter it is now seen as a potentially important heading of civil liability. Another difference exists between what the common law describes as trespass of to land and the tort of nuisance, and what civil lawyers have primarily as part of law of movable property. The choice regarding which part of the vital law obligations is to be used as a solution to emerging legal problems will often depend upon historical factors or doctrines such as the common law doctrine of consideration, which nonetheless make the expansion of contract notions impossible to meet new situations. Conversely, there may be obstructive provisions in the law of tort that make recourse to the law of contract inevitable. This is the case of the German Civil Code, which adopts a weak rule of vicarious liability, allowing masters to exculpate themselves from the wrongs committed by their employees if they can show that they selected and supervised them properly. In such circumstances, some systems, such as the German, have found that resource to contract provisions may make the imposition of liability easier, even though it may give rise to different problems. Intentional interference. All legal systems offer extensive protection to life, health, and physical integrity, to which they attach great importance. Most tort rules covering intentionally inflicted personal injury, though important, are handled by the criminal courts, sometimes with the plaintiff also appearing as a civil party and claiming damages, as in France. Tort law's main contribution is accordingly found in the numerically more significant negligent interferences with life and physical integrity, to which the rest of this article is limited. Land and its enjoyment. In modern civil law systems, protection is given by provisions found in both the property and tort sections of the codes. Common law systems give property owners equivalent protection, but through the law of torts. Thus, direct physical intrusion on the property of another falls within the province of the old tort of trespass. This succeeds without any proof of special damage and is defeated only by rather narrowly defined pleas, such as that of imminent necessity to protect the intruder or his property, or inevitable accident. Other interests in land, however, receive a more qualified protection and must yield to the test of reasonableness, a miscellany of wrongs ranging from encroachment of branches or roots to falling tiles or slats from nearby roofs, are covered by the amorphous tort of private nuisance, which also covers such interference as excessive vibrance, noise, smells, and other more modern instances of pollution. The emphasis is not unreasonableness of the defendant's conduct as in the tort litigants, but on the unreasonableness of the interference with the plaintiff's use and enjoyment of his land. The unifying element is the type of harm, and the law's overall aim is to protect an individual's right to enjoy the amenities of his land within the general framework of give and take necessary is an increasingly crowded world. Balancing competing interests is therefore the key feature, and numerous judgments make it difficult area of law. Its particular interest lies in the fact that, along with other branches of the law, administrative law and criminal law mainly, it can help perform zoning functions in the use of land. However, attempts to utilize it in protecting the environment have not, on the whole, been very successful. In short, this is an old tort that has been deployed to cope with modern developments, especially by North American systems. The gravity of any interference with the plaintiff's land is a major consideration. Older English decisions distinguish between sensible material damage to the land and mere interference with its use and enjoyment. The distinction, not found in any great form in civil law systems, is, however, often unworkable, and to the extent what it reflects past valuing of tangible forms of property over intangible ones, it may be inadequate. The duration of the interference may also be crucial, temporary annoyances being on the whole more tolerable. This the nature of the locality has also been taken into account. This has a mixed effect. However, it is certainly helped preserve rural and residential areas against intruding noxious traits, but it has also permitted increased industrial pollution. Chattels. The law affords wide protection to proprietary interest over chattels. Against the this can involve using a proprietary remedy to reclaim goods removed from their rightful ownership or to claim damages for chattels affected by a tortfeasors, intentional or negligent conduct. Intentional interference with goods is unusual and therefore receives specialized treatment by some systems. Most cases arise in connection with damaged morals, and here the more modern tort of negligence often applies. The problem usually being the extent of compensation. For example, if an automobile is damaged by collision, its owner will be able to claim from the wrongdoer the cost of repairs. But can such cost be claimed if it exceeds that of purchasing a similar vehicle? And what of extra transportation costs incurred during the period of repair or the expense of hiring an equivalent substitute? Even more controversial are recent claims for such injuries as a loss of ruined holiday following damage to the vehicle. Although the later claim tends to be regarded as extravagant and beyond the competence of tort law, at least the others tend to be satisfied, subject to the rules of remoteness and pervading test of reasonableness. The victim cannot hire a luxury automobile to replace a damaged economic. In other instances, however, theoretical doubts may arise as to whether there is interference with property or mere economic loss. For example, if a canal leading to a mill pond collapses, trapping but not damaging the vessel, has the owner of the vessel suffered property damage or mere economic loss, or if a fire forces the police to cordon off an area, depriving its residents of access to their automobiles, have they suffered a properly interference? Sometimes courts focus on the duration of the interference and treat prolonged deprivation as equivalent to property damage. In other cases, however, they treat these instances as cases of pure economic loss and reject the claim for compensation. Negligently inflicted pure economic loss. Economic loss can arise in numerous ways. An employer deprived of the services of a key employee, a child deprived of the financial support of his father, negligent advice given by A to B and relied upon by C, a defective will negligently attested by the lawyers who drew it up, depriving the intended beneficiary of his legacy or negligent actions during road construction that damage municipalities' electric cables, depriving many nearby factories and homes of electrical power. An enduring question is whether all the parties harmed by these activities should be able to recover compensation for their losses. Common law and German spat systems have here faced enormous difficulties, partly because the court's reasoning seems to be motivated by administrative considerations. If one such claim is accepted, many others will follow. Another difficulty system stems from the fact that many of these cases sit uncomfortably on the traditional divide between contract and tort. Yet, third problem arises from the particular structural deficiencies of its system. Protection of honor, reputation, and privacy. The protection of individuals' honor, reputation, and privacy in Western systems is, on the whole, adequate, though it is achieved in varied ways. One factor accounting for the hesitation regarding when to provide protection is linked to the difficulty of balancing privacy rights against free speech. Another is the historical preference of civil law systems for bringing many instances of defamation under criminal law. Finally, the constitutional environment has had a great impact on this part of tort law. In the United States, the tendency since the mid 1960s has been to sacrifice human reputation and privacy to the First Amendment with its ambiguous preference for free speech. Thus, American law does not allow an action at any rate where media defendants are involved unless the plaintiff victim can prove that the allegation was made with actual malice. That is, with knowledge that it was false or with reckless disregard of whether it was false or not. In the United States, plaintiff must also prove that the defendant's statements are false, with the result that many of the traditional common law defense are bypassed. The idea behind this is that any contrary decision restricts the constitutional right to free speech. English law, by contrast, is much more jealous of reputation, though numerous complicated defenses also make sure that free speech is not totally throttled. But in the main, the English law of defamation is complex and archaic. The old distinction between libel and slander, defamatory matter in permanent and transient form respectively, is preserved. The plaintiff is not entitled to legal aid with the practical consequences that only wealthy people can afford to sue. The action can succeed without any proof of special damage, giving an unwarranted advantage to corporations since they thus acquire the benefit of laws designed for human beings. The cause of action does not survive the death of the other party, either party, and finally, juries are often used and are entitled in one of the rare instances of English law to award punitive damages. No summary can do justice to this peculiar but important tort, but according to English legal scholar Tony was a casebook, says casebook on Tort 1974. It may well be that its defect arises. The protection of privacy acquired a new urgency during the later part of the 20th century as increased technological ability to collect, collate, and disseminate information made it possible to interfere with human personality, solitude, and privacy to an unprecedented extent. In some countries, such as France, new articles were introduced in the civil court to deal with the matter, while other passed special legislation dealing with a modern and dangerous form of invasion connected with the data banks and the linking up of information contained within them. To this tendency, even English law has not been immune, though the protection afforded remains patchy and persistent. The creation of general right of privacy was rejected in the early 1970s and again in the early 1990s, partly on the grounds that it was difficult to define, by mainly because of sustained opposition from the British press. Thus, although English law does not recognize a general right of privacy similar to that embodied in the French Civil Code or created by the German courts, it often achieves comparable results, though the ingenious use of existing torts, defamation, trespass, nuisance, passing, or the law of contract, criminal law, or restitution. Now, once again, however, this picture may be about to change as a result of the English Human Rights Act 1998. The growing dissatisfaction with fault. Whatever the original foundations of torturers liability, by the 19th century, it had come to rest firmly upon the notion of fault, the principle that a human being should make good the harm caused by his fault seemed eminently reasonable. But the converse of this principle, namely that there can be no liability where there is no fault, offered an additional attraction to an era that was concerned with not forcing nascent industries to pay sizable hours that they could ill afford at a time of weak insurance practices. In this sense, fault also helped retain the boundaries of liability within manageable proportions. To this coincidence of morality and economic expediency, the notion of fault doubtless owes much of its aura and soundness and inevitability. Consequently, when the first serious challenge to the notion started to materialize toward the end of the 19th century, it invariably had to disgraced. Fault as understood in the 19th century presupposed free will and further that an agent could choose between performing an action in a perceivably dangerous way and performing in some safer way. Thus, legal negligence involved something of personal moral shortcoming. The person who was held liable had been guilty of ethical as well as legal wrong. And since fault involved a more or less informed choice, it was possible to see how the prospect of liability would influence a choice for the better. The concept embodying the principle of social utility for theoretically edified potential defendants by encouraging them to behave more carefully. With the growing mechanization and industrialization of the second half of the 19th century and the resulting multiplication of accidents, this kind of approach came under more and more scrutiny. Consequently, both the moral and the purely educative aspects of the fault system were increasingly questioned, especially as insurance companies were now meeting the cost of accidents. In addition, the idea of leaving victims uncompensated become politically unattractive as the extent franchise made politicians more sensitive to voters' grievances. This change of attitude, however, could not alone have altered the legal system if economic changes had not also favored reprisal of the problems of civil liability. From the turn of the century, industry, with the help of insurance, become increasingly sturdy and less in need of protection. The shift toward the plaintiff's point of view manifested itself in three main ways: greater use of the doctrine of versus liability, increased objectivization of the notion of carelessness, coupled with the use of presumptions of carelessness, and finally, the open introduction of strict liability.
Hello friends, welcome to our channel Law Injury. Here we will take some idea on the basic idea of personal injury in law. There are three types of damage that form the foundation of most civil lawsuits: compensatory, nominal, and punitive. Now we will learn the concepts of personal injury. Any violation of individual's right other than his or her rights in property. The term personal injury is not confined to physical injuries, although negligence cases usually do involve bodily injuries. Personal injury law is a broad field. It covers most cases which involve a bodily injury to a person. Most personal injury cases are the result of an accident, wherein the victim is injured and sues another party for their actions or negligence which contributed to the accident. Now, common types of personal injury cases. Motor vehicle accident. Each year, millions of people are injured, sometimes fatally, in motor vehicle accidents. Medical malpractice, wrongful death, workplace accident, premises liability, products liability, other types of personal injury cases. Now, there are a wide variety of different situations where personal injury rules apply. Personal injury implies any type of injury sustained in accidents. These types of injuries may arise from car accidents, sleep and fall accidents, defective products, or wrongful death claims. On the other hand, bodily injury is more limited and may imply injuries sustained by another person, usually in a car accident. Accidents. Personal injury rules apply in situations where someone acts in a negligent manner and that carelessness causes harm to another person. Examples include car accidents, sleep and fall accidents, and medical malpractice, among other types of cases. Learn more about negligence in personal injury cases. Intentional acts. Personal injury laws apply in situations where a defendant's intentional conduct causes harm to another person. Examples of the include assault and battery and other international torts. Defective products. When a vehicle component, consumer product, medical device, pharmaceutical, or other product is defective or unreasonably dangerous, anyone harmed by use of the product might be able to file a product liability lawsuit against the manufacturer. Defamation. Personal injury laws apply when one person's defamatory statements cause harm to another. Common types of personal injury claims include road traffic accidents, work accidents, tripping accidents, assault claims, and product defect accidents. The term personal injury also incorporates injuries arising from medical and dental care, that which may lead to medical negligence claims. Other causes of personal injury claims include conditions that are often classified as occupational disease. Personal injury cases may also include toxic torts, in which containment transmitted by air or water causes illness, injury, or death. Other tort claims may be pursued in conjunction with personal injury claims. The most common personal injury claims involves injury from motor vehicle accident. Yeah, now who makes personal injury laws? There are various ideas. We will take some idea from here. That is, many personal injury laws date back to old common laws rules. Common laws refers to law made by judges as opposed to laws made by legislatures or passed in bills and statutes. When a judge hears or decides a case, her decision on that issue of law becomes binding precedent on all other courts in the state that are lower than the deciding judge's court. These other courts then have to apply what the first judge said, and eventually all of these binding precedents creates a body of common law. Common law can and does differ from state to state, so the rules for personal injury law may not be uniform across the country. Much of the common law has been collected into something called the Restatement of Torts, which is a sort of guidebook that explains that the rules are, and a lot of states draw guidance from these on personal injury matters. Another state law that comes into play in injury cases in the statute of limitations, which sets a limit on the amount of time you have to file an injury related lawsuit in your state's civil court system. Now we will learn time limits to personal injury lawsuit. How are damages calculated? To get a reasonable starting number for negotiating general damages, many insurance companies and attorneys multiply the amount of medical special damages by a factor of 1.5 to 5, depending on the severity of the injuries. In extreme cases, a factor of more than 5 may be used. Can you sue someone for accidentally hurting you? Yes. If you negligently or unreasonably carelessly injure another person, they can sue you, such as for medical costs, lost wages, and pain and suffering. If they can provide your negligence, they can get a money judgment against you. Now we take some idea how does a personal injury case work. No two accidents are exactly the same. So no two injury cases will follow the same path. But there are some standard steps that most personal injury cases take from a big picture standpoint. Defendant does something to injure plaintiff. This can be almost any bad act on the part of the defendant, with the exception of contractual breaches, which are handled under a separate body of law known as contract law. Plaintiff determines that defendant breached a legal duty. The specific legal duty is going to depend on the situation in which the injury occurred. For example, drivers have a duty to operate their vehicles with the level of care that a reasonable person would exhibit while on the road. Doctors have a legal duty to treat a patient in accordance with the applicable medical standard of care. Manufacturers and distributors have duty not to put defective or unreasonably dangerous products on the market. Settlement talks occurs if it is clear to all involved that the defendant breached a legal duty. Then the defendant or the insurance company representing him or her may wish to settle outside court. This would involve making an offer of monetary compensation to the injured person in exchange for the injured person's binding promise not to file a lawsuit over the injury. If a plaintiff agrees to a settlement, the case ends. If not, the plaintiff may go to court and file a personal injury lawsuit over the matter. Settlement negotiations can also continue once the lawsuit is filed, and settlement can be reached at any time prior to the civil case being handed over the jury for a finding as to the defendant's liability. Historically, personal injury lawsuits in tort for monetary damages were virtually non existent before the Industrial Revolution of the 19th century. In agrarian pre-industrial societies where most people did not travel far from home during their lifetimes, accidental bodily injuries inflicted by one stranger upon another were quite rare. When a grievous accident did occur, the culprit was usually a relative or close friend and part of the same small local community. Most persons were judgment proof before the rise of the middle class and the invention of modern liability insurance. Finally, pre industrial injuries lacked the sheer magnitude of force or of modern personal injuries because they were normally inflicted by humans or animals, not powerful machines. This is the history. Okay, in the 19th century, personal injury lawsuits were filed after accidents on the new railroads. Edward Watkin of the South Eastern Railway, England, complained in 1881 that the result of the compensating law under which the slightest neglect makes the company liable and the only thing to be considered is the amount damages. The effect of this unjust law is to create new profession compounded of the worst elements of the present professions: expert doctors, expert attorneys, expert witness. You will get a doctor to swear that a man who has a slight knock on the head to say that he has diseased spine and will never be fit for anything again, and never be capable being a man of business or the father of family. The result of that is all we can do is get some other expert to say exactly the contrary. Now we will come to claims and payments. Depending upon the intent or negligence of a responsible party, the injured party may be entitled to monetary compensation, yeah, definitely, from that party through a settlement or a judgment. Although personal injury cases may result from an international act such as defamation or from reckless conduct, most personal injury claims are based on a theory of negligence. To hold a party or parties legally liable for injuries, so damages based upon negligence for elements must be proved. The party had a duty to act reasonably according to the circumstances. The party breached the duty. The party's breach of the duty caused you to be harmed. You suffered monetary damages due to harm you suffered when the party breached its duty of care. The amount of compensation of a personal injury will primarily depend on the severity of the injury. Serious injuries such as severed limbs or brain damage that cause intense physical pain and suffering receive the highest injuries settlements. Here we should take a note: must have breached that the duty of care. What is this? To have a claim, there must be a duty of care. The defendant must have breached that duty of care. That breach must have contributed to the cause of the injury, and you must have suffered harm as a result of the injury. You may still be able to make a claim if you were partially responsible for the accident. Now we will take some idea on lawsuits. As occurs in most civil cases, personal injury cases begin by flying with a court of document called a complaint. Typically, a complaint in a personal injury case identifies the parties to the lawsuit, specifies what the defendant did wrong, alleges that the wrongdoing caused the plaintiff's injury, and specifies what kind of compensation the plaintiff is seeking. The complaint generally sets out of the facts that the plaintiff will attempt to prove and the defendant may attempt to disprove throughout the litigation. In most countries, payments will be through a settlement agreement or a judgment as a result of trial. Settlements can be either lump sum or as a structured statement in which the payments are made over a period of time. In some countries, those prevailing in trial may recover their attorney's fees from the opposing party. In the United States, a party may be able to seek sanctions when the other party acts without legal basis or justifiable cause. For example, if the opposing party continues to object to the complaint without significant reason or justifiable cause, a party may apply a motion for punitive damages or that the opposing party is harassing and or speculating without merit or reason. The American Bar Association Model Rules of Professional Conduct proposes that lawyers should be prohibited from bringing or defending a lawsuit unless there is a basis in law and fact for doing so that is not frivolous. The manner in which attorneys are compensated for representing injured plaintiffs varies by jurisdiction. For example, in the United States, attorneys often represent clients on a contingent fee basis, in which the attorney fees is percentage of plaintiff's eventual compensation payable when the case is resolved, with no payment necessary if the case is unsuccessful. Depending upon the state regulations, a plaintiff's attorney may charge 1 by 3 of the proceeds recovered if a case is settled out for off court, or 40% if the matter must be litigated. Attorney fees are negotiable before hiring on an attorney. Although some jurisdictions have historically helped people obtain affordable legal representation, those systems have typically been narrowed and may exclude personal injury cases. For example, in England, legal aid from the government was largely abolished in the late 1990s and replaced with arrangements whereby the client would be charged no fee if her or his case was unsuccessful. Now, time limitation. Many jurisdictions have statutes of limitation laws that determine how much time you have to file a claim. If a lawsuit is not filed in a timely manner, the statute of limitations provides a defense that can allow the defendant to have the case dismissed with no compensation to the plaintiff. In England and Wales, under the limitation rules, where an individual is bringing a claim for compensation, court proceedings must be commenced within 3 years of the date of accident, following which the claimant will lose the right to bring his or her claim. However, injured parties who were under the age of 18 at the time of their accidents have until the day prior to their 21st birthdays to commence proceedings. A court has the discretion to extend or waive the limitation period if it is considered equitable to do so. Another exception is if the accident caused an injury, as an example, industrial deafness, then the 3-year period will start from when injured party knew or ought to have known that he or she had a claim. In the United States, each state has different statutes of limitations, and within a state, different types of injuries may have different statutes of limitations. Rape claims, for example, often have a much longer statute of limitations than other injuries. If some states, such as Colorado, the statute of limitations starts to run once the injury is discovered. For example, if you were in a car accident and then 6 months later started having service back problems, the statute would start when you notice the injury. In India, in case of motor vehicle accidents, there is no limitation for bringing a claim for compensation. This is for your information. Some jurisdictions offer no fault compensation systems for personal injury cases or types of personal injury cases whereby an injured person can recover compensation from a fund or insurance program without regard to who is at fault for the person's injury. For example, in the United States, most injuries that occur while the injured person is working for an employer are compensated through a no fault workers compensation system. In New Zealand, the Accident Compensation Corporation provides no fault compensation to all accident victims, including medical malpractice, and personal injury lawsuits are rare except in cases of reckless conduct. Proponents of this system say that it results in faster, fairer awards to victims. In practice, it can lead to moral hazard as it encourages people to engage in behavior they otherwise would not out of fear of legal ability, such as putting out trampoline or for neighborhood kids to use. Yeah, this is we have learned that no fault compensation fund. Now, personal injury cases in United States. Personal injury cases represent the most common type of lawsuits filed in United States federal district courts, representing 25.5% of cases filed in 2015. Personal injury claims represent a considerably smaller percentage of cases filed in state courts. For example, in Illinois, tort claims represent approximately 7% of the civil docket. The size of the personal injury market in the United States is estimated to be $35.2 billion in 2019, with an estimated rate of growth of 1.3%. In the United States, personal injury in the sense of bodily injury to others is often covered by liability insurance. Most business carry commercial general liability policies. Different states have different rules regarding auto insurance, but generally a driver's liability insurance is available to compensate others whom the driver may be inadvertently injure, and uninsured or underinsured motorist coverage is available to compensate the driver for injuries inflicted upon the driver by someone else. Therefore, an insurance company will provide a legal defense to the defendant and make settlement with the plaintiff victim. Okay, now additional damages for mentally injury without physical injury are less clearly covered, as the insurance policy typically states that it covers only bodily injury. For example, in general liability as of 2001, a minority of courts included emotional distress within the definition bodily injury, where a mental injury arises from physical injury, as with a traumatic brain injury caused by a car accident. Auto insurance policies normally cover the injury. In insurance, personal injury, as typically defined, does not mental injury that occurs as a result of defamation, false arrest, or imprisonment, or malicious prosecution. For example, the Insurance Service Office Standard General Liability Form has a section providing this coverage. Some home insurance policies include personal injury coverage. Despite the general distinction between bodily injury and personal injury in insurance contracts, auto insurance, known as personal injury protection (PIP), that is, does cover medical expenses from bodily injury. This type of insurance is available in some states but not others. In the US, 12 states and Puerto Rico, US territory, have no fault auto insurance systems which provide financial support to people who have been injured in car accidents. Although the benefits will vary depending on the states, no fault benefits will generally pay or an injured person's car crash related medical bills and lost wages to be paid by the insured person's own insurance company, and 3, be paid regardless of whether the injured person was at fault for the crash. In Michigan, there is a catastrophic claims fund known as the Michigan Catastrophic Claims Association that has historically helped catastrophically injured crash victims. Now it's taxation. In the United States, for federal taxes payable to the IRS, the money awarded in a personal injury state settlement as a compensation for pain and suffering, medical expenses, and property damage is not ordinarily taxable. Exceptions may apply. For example, if a plaintiff took a tax deduction in a prior year for medical expenses that are recovered through a later judgment or settlement. Compensation for lost wages or lost business profits will typically be taxed. Now, state laws. In California, attorneys typically receive contingency fees of 35% of the total recovery obtained before a lawsuit is filed, and 45% of the recovery occurs after filing the complaint. In some types of cases, the judge handling the case may determine the total percentage of the settlement or the payment of the attorneys. Treating doctors or healthcare profession and or insurance companies, medical or other program paying for medical treatment may assert a lien against any recovery for what was paid to treat the plaintiff. These liens are paid once the settlement is reached or judgment is received. In California, according to California Code of Civil Procedure, Section 335, the statute of limitations in California is 2 years from the date of loss. A date of loss refers to the date in which the accident has happened. Minors in California who are filing a claim against an entity or person has until 2 years after their 18th birthday to satisfy the statute of limitations. For governmental claims, both minors and adults have 6 months to file a claim with its corresponding jurisdictions according to the Government Code Section 911.2. After filing a claim to satisfy Government Code Section 911.2, you have additional 6 months to file a lawsuit against the government entity. For wrongful death cases in California, people qualify to claim damages if they are the following: the deceased person's serving spouse, the deceased person's domestic partner, the deceased person serving children, or if there is no surviving person in the deceased person's line of descent, then a wrongful death lawsuit may be brought by anyone who would be entitled to the property of the decedent by the intestate succession, which can include the deceased person's parents or the deceased person's siblings, depending on who is sibling at the time of the deceased person's death. Otherwise, plaintiff will have to prove that financially dependency on the deceased person. For automobile accidents in California, a plaintiff must show proof of financial responsibility. California Vehicle Code sections 16,000 to 16,078 and have a valid driver's license to claim economical and non-economical damages. Proving the minimum financial responsibility means that a person must be insured by the state's minimum coverage of insurance, which in some cases may be referred to limited liability type of insurance. If the person at fault cannot prove financial responsibility, a plaintiff may be unable to obtain damages as the person at fault may not be properly financially able to pay for those damages. So, thank you for our having the basic ideas. We will meet again in a next video with some new ideas and basic concepts in law injury in different picture. Thank you.